In this video, we're going to talk about plea bargains, why they exist, how they come about, what they are, and just answer some general questions. And a lot of people will ask, why doesn't every criminal case end in a trial? The simple fact of the matter is, the justice system is not designed for every single criminal case to end in trial. A lot of times, the state and the defense lawyer will talk out a case. They will be able to articulate the positives in the case, the negatives in the case, and the risks involved with taking a case to trial. And then generally we'll come to some sort of compromise and that the defendant can live with, which will help mitigate their risk of going to trial and potentially losing. What is a plea bargain? Well, a plea bargain is simply an agreement between the prosecution and the defense where the defendant will plead guilty or no contest in exchange for something from the state. There are all different types of plea bargains. Charge bargains, for example, you're charged with a felony, that might get reduced to a misdemeanor. Sentencing plea bargains, where both sides may agree to a lesser sentence than the person could potentially get. The number of counts, that's another plea bargain where some charges might be dropped. Say you're charged with 5 or 6 counts and you might get that dropped to 1 or 2 counts in exchange for pleading. Now that we understand what plea bargains are, why are they even offered? It just depends. For prosecutors, working out a plea saves time. It ensures they might get a conviction. It avoids risks of trial, whether the state might win or lose. For defendants, accepting a plea bargain provides certainty. A defendant might know what's going to happen in their case or really limit their exposure. And it can potentially reduce a penalty someone might be facing. And it avoids the stress and cost of trial. Now for the courts, it keeps the system moving. Having plea bargains, the court is not capable of jury trying every single case that gets filed in the court. So a lot of cases work out through plea bargains, and that simply saves the court's expense, time. So you may ask, what is your role in the plea bargaining process and what is your attorney's role? Well, your role is to listen to your attorney and weigh out the risks associated with potential pleas, weigh out your risks of trial, whether or not you think you're going to win or lose, and sit down with your attorney and get a real-world perspective on your chances at trial. Now, your attorney's role in the plea bargaining is going to be negotiating with prosecutors. That may entail giving you a list of stuff to do to arm your attorney with some good ammo, so when they go talk to the prosecutor for this negotiation, they can give the prosecutor some mitigating circumstances or potential defenses in the case. Another role is for your attorney to explain the risks of trial, the benefits of a plea, and the drawbacks of the plea. You need to sit down with every single proposed plea offer, go over it with your lawyer, and make sure that you understand it and that you're adequately advised before you say, yes, I want to take it, or no, I don't. Remember, ultimately, it's not your lawyer's decision on whether you take a plea or not, it's your decision. So you need to be adequately advised about the intricacies of every plea offer that's offered to you.